India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. As you know, we are the nation's first politico-legal independent weekly, focusing on controversial issues of national and international importance. The video readouts we present to you regularly are the editorial team's choice of the most significant stories we believe should receive close and scrutiny and wide circulation. You can watch them along with the visuals or listen to them as you would a podcast. Now, the topic for this commentary is an unusual one this time and rarely discussed. It is the right to be forgotten. Our audience may scratch its collective head at this strange phrase, wondering what on earth is all this about? Most people like to be remembered, not forgotten. True? True? Well, not quite. How would you like it if, say, after 20 years, your name came up in a website search as a teenage, say, rapist, even though you had been absolved of all charges? Yet the original charge sheet remained posted on Google. What if you'd been convicted for a misdemeanor in your youth but let off for good behavior and made to do community service and rehabilitated, but a search showed you as a criminal? Do you not have the right to get these records expunged? Now, the India Legal Bureau has written a thoughtful analytical piece for the magazine which is the subject for this readout. The India Legal team, with associate Shivam Sharma taking the lead in researching this piece, notes that Google India has told the Delhi High Court that the right to be forgotten has various nuances and passing protective orders would depend on the facts and circumstance of each case. On July 21, 2022, just recently, while hearing a batch of petitions filed in the Delhi High Court seeking protective orders in the light of the right to be forgotten application, Google India said that it differed in different cases. The right to be forgotten allows people to request URL delisting. You know, URL is the address that you put in the search bar on your computer or your smartphone. To request the URL delisting on Google, but not for certain countries. India, for example, Google India submitted before the bench of Justice Yashwant Verma that this right has various shapes and shades, and therefore passing off protective orders would depend on the facts and circumstances of each case. Now, the counsel for Google argued that one blanket order cannot determine the width of the right to be forgotten. While stating the Delhi High Court had recognized the right to be forgotten, the counsel said that the first ex parte order passed in this matter was being used repeatedly as a precedent in different courts and causing a snowballing effect. He also said that the court had set up committees to look into what had to be done, and the respondent had no problem with that. Now, while considering the submission, the High Court directed that Google India was to be deleted and Google LLP was to be impleaded as a party. In Joravar Singh Mundi versus Union of India, the Delhi High Court in April 2021, last year, had reached the conclusion that the right to be forgotten is intangent to the right to privacy. Now, the matter related to an American citizen who had visited India way back in 2009. However, a case was filed against him under the Narcotics, Drugs and Psychotropic Substances Act of 1985. A couple of years later, a trial court acquitted him in its verdict on April 30th, 2011. In a ruling on January 29, 2013, a single judge of the Delhi High Court affirmed his acquittal on appeal by the state. Now, the question as to whether a court order can be removed from online platforms is an issue which requires examination of both the right to privacy of the petitioner on the one hand and the right to information of the public and maintenance of transparency in judicial records on the other hand. The legal issues would have to be adjudicated by this court, the bench of Justice Pratibha M. Singh had observed. The court based its decision on the Supreme Court's order in K.S. Puttaswamy versus Union of India 2017, landmark case by the way, which recognized the right to privacy. It also relied on its own order in Zulfikar Ahman Khan versus Quintillion Businessman Media Private Limited in just last year 2021. Further, the Orissa High Court had also recognized the right to be forgotten in Subhranshu Raut versus State of Odisha the previous year, 1 year earlier, that's 2020. The court had examined the aspects and applicability of the right of in the capacity of the right to privacy, including the international law on the subject. The right to be forgotten is the right to have private information about a person removed from the internet searches and other directories under some circumstances, as I said earlier during the beginning of this commentary. It bears repeating for it to be understood in its entirety. The right to be forgotten, in fact, reflects the claim of an individual to have certain data deleted so that third persons can no longer face them. It has been defined as the right to silence on past events in life that are no longer occurring. The right leads to allowing individuals to have information, videos or photographs about themselves deleted from certain internet records so that they cannot be found by search engines. The issue arose from desires of individuals to determine the development of their life in an autonomous way without being perpetually or periodically stigmatized as a consequence of a specific action performed in the past. Due to the vagueness of the current rulings attempting to implement such a right, there has been a controversy about the practicality of establishing the right to be forgotten in respect to access of information as an international human right. The right to privacy is well recognized by the Supreme Court in our Constitution. In fact, there is a Constitution bench judgment in Puttaswamy that referred to earlier versus Union of India back in 2017. In a landmark judgment in August 24, a 9-judge bench of the Supreme Court unanimously ruled that individual privacy is a fundamental right. The judgment was delivered on a PIL filed by former Karnataka court judge K.S. Puttaswamy way back in 2012, challenging the Aadhaar scheme. 6 separate but concurrent judgments were written by the bench on the issue. In Zulfikar Ahman Khan versus Quintillion Businessman Media Private Limited, mentioned earlier, the Delhi High Court had examined this issue, and while granting an interim order, it held that recognizing the plaintiff's right to privacy, of which the right to be forgotten and the right to be left alone are inherent aspects. It is directed that any republication of the content of the originally impugned articles dated 12th October 2018 and 31st October 2018 or any extracts or excerpts thereof, as also modified versions thereof on any print, digital, electronic platform shall stand restrained during the pendency of the present suit. The plaintiff is permitted to communicate this order to any print or electronic platform, including various search engines, in order to ensure that the articles or any excerpts, research results thereof are not republished in any manner whatsoever. The plaintiff is permitted to approach the grievance officers of the electronic platforms and portals to ensure immediate compliance of this order. So the court states. In January of 2017, the Karnataka High Court upheld the right to be forgotten in a case involving a woman who originally went to court in order to get a marriage certificate annulled, claiming to have never been married to the man on the certificate. After the two parties came to an agreement, the woman's father wanted her name to be removed from search engines regarding criminal cases in the High Court. The court approved the father's request, stating that she had a right to be forgotten. Businesses that manage their clients' online reputations have responded to the European court ruling by exercising the right to be forgotten as a means to remove unfavorable information. Now, one technique used by reputation consulting firms is to submit multiple requests for each link, written with different angles in an attempt to get the links removed. Critics say that the right to be forgotten would restrict the right to freedom of speech. Some academics opined that only a limited form of the right to be forgotten would be reconcilable with US constitutional law, the right of an individual to delete data that he has personally submitted. In this limited form of right, individuals cannot have material removed that has been uploaded by others, as demanding the removal could constitute censorship and a reduction in the freedom of expression in many countries. Now, the debate is multifaceted. What is most needed is calibrated reasoning and balanced judgments that safeguard the right to protect privacy and reputations, along with upholding freedom of information. This is your host, editor Inderjit Badhwar. Until next time, goodbye for now.
India Legal, stories that count.